So thank you very much, everybody, for attending. My name is Oscar Miklos from Refresh Law. We're a law firm based out of Burnaby, British Columbia. But my associate, one of my associates, Jennifer Lebert, is based out of Comox. So, you know, we have a presence, physical presence as well on the island, on top of the fact that we have many clients on the island. As a firm, our practice is kind of split down the line between residential tenancy matters and strata property matters. And so, you know, we find that the two areas of law are actually rather intertwined, you know, and especially now with the passage of Bill 44, where, you know, even if you had a strata corporation that was a non-rental strata, all of a sudden you are now faced with the you know, likelihood that you're going to be dealing with some sort of rentals. And today's presentation is also going to kind of be a dual-pronged presentation, which is to say we're going to be focusing on residential tenancy stuff and strata property stuff there as it relates to, as you can see on the title of the presentation, the Airbnb problem. So the questions that I wish to answer today are well, threefold there. We're going to first and foremost talk about how we characterize short-term accommodations and how they differ from typical or traditional residential tenancies. Then we're going to talk about how we can prevent short-term accommodations. So again, you know, obviously the underlying assumption is that they are a problem. And then we'll take a look at both from the strata and the landlord or residential tenancy perspective, what you can do to prevent them from happening. And then the final part of today's presentation, other than the Q&A at the end, which, like I said, we'll leave some time for that, but the final part of today's presentation is remedies, which is to say, when something has already occurred, when we have a problem, then what kind of steps can we take to rectify the situation? But before we dive into any of that, we now actually have real life stories to share, some stuff that has made it into the news media. It's a case of a woman named Emily Yu from North Vancouver. And Emily owned a 3-bedroom, 5-level townhome unit. We'll refer to that as Strata Lot 12, that she purchased in September of 2014. And Emily used Strata Lot 12, which she branded as the Oasis Hotel, as an Airbnb unit since at least 2016. So a couple of years after she purchased townhome, she decided to convert it into a short-term rental. And she would do so by renting out as many as 15 beds and up to 20 short-term boarders at any one time. And she would charge them anywhere from about $50 to $102 per night. Now, in September of 2016, so fast forward to you know, a couple of years after she purchased townhome, and a few months into her converting the townhome unit into Airbnb accommodation, the Strata amended its bylaws to address Emily's conduct, but her use of Strata Lot 12 as an Airbnb unit actually escalated after that. So despite the fact that the Strata passed a bylaw, you know, Strata Council probably thought that, hey, problem solved. Well, no, actually the problem got worse. In late March of 2017, the City of Vancouver inspected Strata Lot 12 and determined that Emily was using it as a tourist accommodation use, contrary to its own approved use of the dwelling as a townhome or townhouse residential unit development, and also found non-compliance with the city's zoning bylaws. So now we have a situation where A, Strata's bylaws are not being adhered to, and B, the City of North Vancouver also has something to say because they also determined that there are municipal bylaws that are being violated. Story continues. In April 2017, other Strata Lot owners observed several beds and mattresses being delivered to Strata Lot 12. There are concerns from a neighboring owner that included fire hazards due to block exits and clutter, high traffic of smokers outside, and the use of shared kitchens, threatened security due to the volume of strangers in the complex, lack of insurance that may not cover any damage done by Emily's, we'll call them so-called tenants, but really it's occupants there. Increased risks of bed bugs, excessive noise, strangers using the parkade, overuse of shared services such as garbage and recycling. Again, I go back to this, right? There's a train of thought that says that Airbnb is good or is acceptable, but as you can see here, there's a number of concerns, and probably there are more, but a number of concerns that are associated with Airbnb. Two of the Airbnb renters provided written statements, each complaining about the conditions in Strata Lot 12 and the fact that the home was filled with about 20 people. It's not quite clear the exact number of people Emily had staying in Strata Lot 12 at any given time, but it is undisputed that she used it as an active Airbnb unit in 2016 and 2017. Now, later on in this presentation, we'll talk about how Miss Yu's story actually concluded. We'll leave it at a little bit of a cliffhanger for now, and then we'll make sure that you are not left hanging by the end of the presentation here. So we'll talk about characterization. From a legal standpoint, the question is, how do we characterize short-term accommodations? And how do they differ from regular, traditional residential tenancies? So residential tenancies are governed by the Residential Tenancy Act in British Columbia. At law, tenancies are said to create an interest in land for the tenant. And the practical consequence of this is that tenants obviously have many more rights than just an ordinary occupant. Generally, tenants have exclusive possession of the rental property for the term of the tenancy, as long as they keep paying rent. Tenants have the right to sublet the rental property with the consent of the landlord. Tenants also have the right to assign their lease with the consent of the landlord. An assignment differs from a sublease in that under the assignment, the original tenant's obligations are extinguished and replaced by those of a new tenant. So that's what we mean by assignment. And any sort of dispute resolution goes through the RTB, the Residential Tenancy Branch. Now, short-term licenses or accommodations are, they're often referred to as rentals. It just feeds into this confusion basically because, again, the more accurate term is a short-term license or, my preference, just a short-term accommodation. Now, a license generally grants permission to use something, and this permission can be revoked. Parties may agree that the occupier can be evicted without a reason, or that the occupier may leave without notice. So in that sense, when you compare it to a residential tenancy, a license to use something is generally a lot more flexible. Now, Section 4 of the Residential Tenancy Act actually provides the following exemptions where the Act does not apply. And I think there's two important considerations here. One, living accommodations in which a tenant shares a bathroom or kitchen facilities with the owner of that accommodation. Okay, that's one. And the second, there are more, by the way. There's a list of about 10 or 12, or I don't know how many exactly, but there's many different situations where the Act does not apply, but I'm talking about the ones that are specifically related to or pertinent to today's presentation. So the second one is a living accommodation occupied as a vacation or travel accommodation. So now we get to a little bit of a game here. And we're going to have three scenarios where the question is just going to be tenancy or license in each of them. So I'm going to read out the scenario here, and then we'll let you guys all vote and see what you think there. So the first scenario, based on, and this is going to test whether you've been paying attention here. So you didn't think you were going to get a test on a Sunday afternoon there, but here we go. So scenario one, a Strata homeowner owns a 2-bedroom condo with 1 bathroom. He has no use for the 2nd bedroom and decides to list it on Airbnb. So, based on the information that I provided before, Is this going to be a tenancy or a license? Please vote now.
We had 80 people respond, and 18 said they thought it was a tenancy, and 62 thought that it was a license.
All right. Well, those of you who answered license, you are correct. It would fall under the RTA exemption for shared kitchen or bathroom with an owner. Okay. So if you think that the Residential Tenancy Act would apply in this case, it doesn't. Okay, now we're going to go with scenario number 2. Scenario number 2, a tenant is renting a 1-bedroom condo. He decides to leave on vacation to Europe for a week. He lists his entire condo on Airbnb for that 1 week. Tenancy or license?
Okay, I'm going to end the poll. This was neck and neck. We have 39 people who think it's a tenancy and 43 who think it's a license.
All right, well, the answer is it's kind of a trick question here because it could be either depending on the facts. So this one really forces you to think there. Because if there is a licensing agreement signed, adjudicator would take that into consideration. If there's no licensing agreement, you'd have to take a look at the conduct and expectation of the parties. So it certainly seems as though the Airbnb occupant would have an exclusive possession, even if it's only for 1 week. So it could potentially be a rental there. However, in the event that it's found to be an accommodation for purpose of travel or vacation, it will be exempt from the act. Okay, scenario number 3. A tenant is renting out a 2-bedroom condo with 1 bathroom. When he signed the lease, he had a co-tenant who was paying rent and using the 2nd bedroom. His co-tenant has since moved out though, and he figures that he could be making more money just by listing the 2nd bedroom on Airbnb instead of getting a permanent roommate. So again, question, tenancy or license? So I see here 79% says it's a license and 21% says tenancy. Well, I'm going to give you the lawyerly answer again, which is it is actually a trick question. Again, it depends on the facts. The Act grants an exemption where the tenant shares a bathroom or kitchen with the owner of that accommodation. In this case, though, while the Airbnb occupant would be sharing a bathroom, it wouldn't be with the owner. So it would be with the tenant, right? So that exemption is not applicable here. But you would once again have to consider whether the Airbnb occupant is using it for the purpose of vacation or travel accommodation, in which case it may fall into the 2nd exemption, in which case we're back to licensing. So I think the voting was pretty well, where I expected it to be. And again, though, I think that the bottom line is you really have to dig deep and kind of consider what the intention is of the parties and then what the use was as well there. So now that we have, delved into this exercise of distinguishing between short-term accommodations and traditional tenancies, let's look at a way how we can prevent short-term accommodations. And we'll look at this, as I promised, from both the strata perspective and the landlord perspective. So when short-term accommodations first became an issue, stratas would simply apply or try to apply existing rental restriction or prohibition bylaws to short-term accommodations. Short-term accommodations are not residential tenancies at law. And so rental restriction bylaws would not actually have the effect that strata councils were hoping for. This was actually confirmed in now what is the leading decision on short-term accommodations, the Supreme Court's decision in High Street, and I've included the reference there if you're keen on reading court decisions, then it's great. If you're suffering from insomnia, it's also a great way to cure insomnia, reading court decisions. But in this decision, the applicant was arguing that the grandfathering provisions of the Strata Property Act that applied to rentals would also apply to their units. They were doing short-term accommodations. And the court basically took a look at the situation and said, no, residential tenancies are not the same thing in legal nature as short-term accommodations. Therefore, the Stratas bylaw that upholds short-term or prohibits short-term accommodations applies here, and applicant, you're not permitted to do that. right? So that's kind of the Coles Notes version of the case there. The gist of what we can take out of that. Now, in 2018, the Strata Property Act was finally amended to create a viable enforcement mechanism against short-term rentals, right? We're going to have a situation where we're going to be able to fine up to $1,000 for every infraction. And if it's a continuing infraction or a continuing contravention, as the Act calls them, we're going to allow you to do that daily. So it's $1,000 a day. Right now, if you get out your calculator, you're going to say, you know what, this is going to become a lot more expensive here, right? To the point that I go back to this, creates a viable enforcement mechanism against short-term rentals. And then, of course, 2022, a few months ago there, rental restriction and rental prohibition bylaws were removed. However, short-term accommodation prohibition bylaws are still enforceable. That's very key to remember there. So what is the best way to protect your strata against short-term rentals? Well, you have to adopt a use of property bylaw, and this bylaw may read something to the effect of a strata lot must not be used by an owner, tenant, occupant, or visitor for short-term accommodation purposes such as a bed and breakfast, lodging house, hotel room, timeshare, vacation rental, yada, yada, yada. The bylaw wording should also ideally ban the advertising of short-term accommodations. Okay, so the reason I suggest this is because from an enforcement standpoint, sometimes it's a lot harder to prove that an accommodation actually took place versus just printing out the ad on Airbnb or wherever, whichever other website that this is being hosted on, and saying, aha, here we go, we caught you, you're advertising this, right? And then, of course, the maximum fine section of your bylaw should also be updated, which is to say that even if you have, this is probably more relevant for most of the council members. You may already have a short-term accommodation bylaw, right, or prohibition bylaw. Check if you have updated your maximum fine section to also make sure that you have the enforcement mechanism, which is now $1,000 a day per contravention per day there. Make sure you have that, because otherwise, I mean, it's still a bylaw violation, but you don't have the real threat, which is what you need here to prevent them. So in absence of these bylaws, you should also consider municipal bylaws. Even if you don't have a short-term accommodation bylaw, there are still other ways that you could possibly, kind of roundabout ways that you could possibly go about preventing short-term accommodations. If you feel that there are potential violations of municipal bylaws, you can also report that to municipalities. Now we get to residential tenancy agreements. So the Residential Tenancy Act states, and the standard terms of tenancy agreement state that, if a tenant is going to sublet, then in all situations, they're going to have to get the consent of their landlord before doing so. Okay, but this sublease implies, or would imply, that you're still in the context of a residential tenancy, right? And we just talked about that these accommodations may or may not be considered, likely won't be considered, certainly not in the strata context, tenancies, right? So, much in the same way that stratas are going to be looking at applying use of property bylaws, you can, in your residential tenancy agreement, mimic this same type of language to prevent the tenant from using the rental unit for purposes of short-term accommodations. You may want to put into the tenancy agreement that this is a material term, material being very important, right? But I would also put in an additional wording of something to the effect of, that the tenant must or agrees to comply with the strata's bylaws, which again means that if the strata corporation, in the context of a rental unit, if they have a short-term accommodation ban, the strata bylaws require that you don't engage in those type of accommodations. So, remedies and recourse. What happens when there is already a problem and you want to get rid of it? As you may know already as council members, the main tool for enforcing bylaws, or at least the knee-jerk reaction, as I call it, is to impose fines. The Strata Property Act, section 135, does outline a procedure that you have to follow to impose or to create enforceable fines, right? It's not just a matter of sending a simple letter to an owner saying, boom, you've been fined, right? There is a procedure. Please make sure you're aware of that. I'm not going to get into that in the context of today's presentation, but just make sure you're aware of that. Now, let's say you do create an enforceable fine. The scary part is if you're a landlord, and if it's a tenant that breaches the bylaws and gets fined, the strata can actually choose who to go after to collect the fine, assuming that they followed the proper procedures to create a fine and to notify both the tenant and the landlord. More often than not, it's actually easier to collect from the homeowner than it is to collect from the tenant, who may have already vacated by that time. The strata may apply to the CRT above and beyond fines. The strata may apply to the CRT for what's called injunctive relief. So an injunction, it's an order to do or to not do something, right? I always say this, right? Start with fines, but once you get to a certain point, and if fines are not a sufficient deterrent, then you're going to eventually need to take a next step. And so, one possible step is to apply to the CRT to get what I mentioned was the injunction, an order to do or not to do something. In the most recent cases, what they've said is that you can get a partial recovery of legal fees, and that whether you recover or not will depend on whether those legal fees are associated with something that was related to the CRT application itself, or whether it was for anything done pre-CRT there. Okay, so don't expect full recovery of legal fees, what I'm trying to suggest there. But if you have a bylaw in place that allows for the recovery of legal fees, then you could at least make it a little bit worthwhile in terms of what you're going to do there. And then finally, in response to Bill 44, the RTB, the Resident Tenancy Branch, has actually updated its own guidelines to allow what has always been allowed under the Act, but for practical reasons has not taken place. They now allow for a strata corporation to evict a tenant. The RTB is coming up with a new form to allow a strata corporation to issue a notice to end tenancy to a tenant. And so this is a brand new kind of, again, untested waters there for now, uncharted waters, but it's something that is exciting because it prevents another, or allows for another possible alternative for strata corporations to resolve disputes there, especially when it comes to problematic tenants there. So tenancies. Recovery of fines. If the landlord pays tenants fines, they may recover this amount from the tenant. Okay, so that's also in the Strata Property Act. And then, from a landlord perspective, you also have to consider, if your tenant is breaching the bylaws, then, and especially if you're getting fined for it by the Strata Corporation, that's a problem for you. So you may look towards, evicting a tenant yourself. But there are multiple potential grounds for eviction. So tenant has permitted a person on the property that has interfered with the disturbed another occupant, put the landlord's property at risk, illegal activity, breach of material term of the tenancy agreement. If you have in your tenancy agreement that you're not allowed to do short-term accommodations, then this could be grounds for eviction. And if you consider, if you want to take a gamble or roll the dice on this and say that's a sublease without consent, and so ultimately when you're looking to evict a tenant, my best tick all the boxes on the eviction form that you think may apply, because it's better to do more and find out that only one applies. Only one needs to apply. right? At the end of the day, but in case of doubt, tick more boxes than less. Okay. Now, finally, we get back to our friend Emily Yu. So this is the textbook example of Airbnb gone wrong. The Strata Corporation ended up getting an injunction against her at the Civil Resolution Tribunal. So we talked about that as one enforcement mechanism. Ms. Yu chose to ignore that order, which then became a contempt of court matter before the Supreme Court. So if you don't obey a CRT order, that's something that, again, can be taken up at Supreme Court. And Supreme Court, in this case, ordered Ms. Yu to pay, in addition to the fines levied against her, the Strata's legal fees, which by that point totaled about $52,000. And once she failed to make payment to the Strata Corporation for those fees and the fines, thereby continuing to ignore the court order, then the Strata applied for enforcement of that order by a court-ordered sale of her Strata lot. And I don't have any, proof of this, but I suspect that there may have been some sort of mental health issues as well in this case that led to the result that it did. But ultimately, the bottom line is that this was a blatant, straightforward violation of the Strata's bylaws. We talked about municipal bylaws, and then we continued with the disobedience of tribunal orders and then court orders. So this is like I said, the extreme example of what can happen if you just continue to refuse to comply, right? So my name is Oscar Miklos. Again, I'm from Refresh Law. I'm going to give you the contact information. So we have our office located in Burnaby, British Columbia, but we are fully operational everywhere in BC there. Feel free to reach out if any of the issues that we've discussed in today's presentation, if you find that you're having those issues, and obviously anything else Strata related. So questions?
Are there any mandatory grandfathering of conditions? For example, if you had been doing short-term rentals and then a bylaw was subsequently put in to prohibit them, are you allowed to continue because you were doing it before?
The answer quite simply is no. As far as short-term rentals are concerned, upon passage of the bylaw, upon adoption of the bylaw, it becomes a bylaw of the Strata Corporation. But don't forget, this is very, very important, register your bylaw. In order for it to be enforceable, it has to be registered in land titles.
Okay, so here's a good one, and we've had lots of questions about this, and it's about the definition of a short-term rental in terms of amount of time.
Yeah.
So let's flip that around, because
Yeah.
you've mentioned municipalities, and different municipalities have different definitions.
Yeah.
What could a Strata do in their own short-term rental banning bylaws to address this lack of definition?
So it really depends. It's, if you want, you can certainly, and I can include a definition within the bylaw that says for purpose of short-term accommodations, this includes stays or accommodations, licenses, whatever that are 30 days and under. And if that helps you, great. But it seems to be that, there's a trend that more people just kind of want to keep it general and apply for example, the Residential Tenancy Act to differentiate between, whether it's a traditional rental or if it's a short-term accommodation in the sense of what we talked about.
Okay, so the next question I actually asked the person for clarification, but basically the idea is if you have an age restriction bylaw 55 plus,
yeah,
does that apply to the hotel guests who are staying as short-term accommodation?
Okay, that's very good. So I would think that if you have a carefully worded age restriction bylaw, then you could extend that to any sort of occupant or resident, basically, of the property. Most of the age restriction bylaws that I've seen, I'm not sure if they would apply in the context of short-term. So the wording that I've seen, I think would likely not apply.
Kind of a similar question. In this case, it's about maximum occupancy. So if you had a maximum occupancy bylaw of say 2 persons per unit, can that be applied to the short-term rental? And I'm going to elaborate on that and say, if you were not going to ban short-term rentals, but you were going to limit short-term rentals, could you make that maximum persons, put it right in your short-term bylaw?
Right. So again, right. So we're talking about, you know, again, some of these maximum occupancy bylaws will contain, you know, a definition of who is an occupant, right, versus a visitor. And then the question is the, you know, person who's staying because of a short-term accommodation, a visitor or an occupant, right? So if they're not an occupant, then the occupancy bylaw wouldn't apply to that. But I guess you could potentially stretch the definition. And, you know, to Wendy's suggestion, could be very interesting. You know, I've had strata councils who have made the decision that they don't actually want to prohibit short-term rentals, but they want to regulate short-term rentals. And in those situations, you could ostensibly draft a bylaw that says, you know, yes, you're limited or you're able to do short-term rentals if you comply with the following requirements, among which that you have to get a short-term rental business license from the applicable municipality, right? That may actually carry with it some other, you know, requirements, such as that it's your principal accommodation. And then within the context of that same bylaw, you know, you could potentially put in there some sort of maximum occupancy for your your unit as well, to say that you can't be like Miss Hugh here and you know, have a townhome full of about 20 people, right? Yeah. So that is an interesting. I mean, I haven't seen. I mean, I've had clients who've asked for you know, restrictions or regulations concerning short-term rentals. I don't think I've had a client who's yet asked me to put a maximum occupancy within that, but I don't see why it couldn't happen there if you wanted that to happen.
The next one kind of ties in with this, and I'm going to shorten the question to basically, you have no short-term rental bylaw about banning or limiting, but there is a municipal bylaw. Complaints have been made to the municipality and they're not enforcing it. Mm-hmm. Any comments on what to do in that case?
I actually, you know, find it problematic for a strata council to try to take a set of rules that that they had no, you know, involvement in writing, and presumably as well, if you know, I mean, if you want to ban short-term rentals, you know, throw it to the owners and see if they have a 3/4 vote, basically, that can, you know, prevent this from happening, right? Or adopt a bylaw to prevent short-term accommodations. But you know, if you've done that and if it's failed, then, you know, my argument would be, well, the ownership has made a decision to you know, to allow these. But you know, there are, as I mentioned, kind of workarounds specifically related to municipality, and the one of the, you know, standard bylaws that you're looking at, you know, I mean, I'll have to find exactly the wording there, but it says something effective, you know, thou shalt not do anything illegal with your strata lot. And so if you are in breaching, so the argument would be, if you're breaching a municipal bylaw, then you're also, conversely, or in the same line of thinking, doing something illegal with your strata lot, and therefore it becomes a strata bylaw enforcement issue. So even if the municipality is not enforcing its own bylaws, in theory at least, the strata corporation could start up legal action at the CRT and argue that the person in question is actually breaching the municipal bylaws, and by doing so, they're actually breaching the standard bylaw that says don't do anything illegal with your strata lot, and therefore it also becomes a strata issue. Now the question here is, if the municipality has not done anything in terms of enforcement, then is there yet a breach of the municipal bylaws? You know, has that even been determined? I would still argue, as a devil's advocate, I'd say, well, you know, the municipality still has the ultimate say in whether, you know, their bylaws are being breached. So if you have no action taken by the municipality, you know, I think it would be a, I don't want to call it a Hail Mary of an argument, because I still think that there's an argument there, but it'd be a, optimistic argument, I think, to make, to try to, make the argument that I was just talking about.
Okay, last question, because this has come up before. What if you don't have a bylaw banning short-term rentals, but you do have the bylaw saying that you can't run a commercial business? Does that cover it, or do you still need a short-term rental ban bylaw?
Good question. I haven't seen any cases that, at least that I've come across there. Maybe at the end of today's presentation, I might actually take a look and see if there, by any chance, anything that has come up more recently. I've never seen a no business or no commercial business bylaw applied for short-term rentals in the context of CRT. It's usually if the problem is short-term rentals, you'll have a specific bylaw that addresses that. But to the extent that on its face, they're going to have to see the wording of that of the no business or no commercial activity bylaw to kind of verify or to give you an opinion about the applicability of that. But ostensibly you could interpret that to apply to this situation as well, to the extent that you can say that short-term accommodations are businesses. So I don't see why you couldn't make that argument, but it goes back to kind of like what I said before. If your goal is to ban these type of accommodations, just pass a bylaw that says that's what you're doing. That will remove any sort of debate. Because if there's anything, again, as lawyers, we're risk managers, right? If you take a, no commercial business bylaw, and try to apply it here, then I'd say, okay, well, look, we'll try it. It's doable, but there's still that element of, it's not quite proven. Whereas we have tons of CRT cases now and Supreme Court decisions as well that talk about short-term rentals and use of property bylaws. So if you already have those, then use those. Then don't try to reinvent the wheel here. That's unless you need to.
So in short, at Vizoa, what we say is if your goal is you don't want short-term rentals, talk to a lawyer. These are complex bylaws. Don't try to write them yourself. The Supreme Court has waffled on this word or that word or this comma. They're pretty complex. You need legal advice. That's all I have to say. Again, thank you so much for joining us today.
Thank you very much, Wendy, and thank you very much to all the members who were in attendance today. I look forward to hearing from you, and hope, and if not, then I assume everything's well. So.